litigate. And there may be others. We're going back through, I will tell you, Mr. Murdoch passed a polygraph, flying colors. So the same polygrapher.
Now let me repeat that. The defense claims cousin Eddie, a potential witness, failed a polygraph when asked if he killed Paul and Maggie. Alec Murdoch passed the same test. Creighton Waters fired back at that claim.
The case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that, in the subjective opinion of the examiner, may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries. And that's, of course, for the ultimate determination of the truth of the matter. And so, obviously, from the state's perspective, if there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that witness and that officer or whatever does not say the P word out loud. And that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that. And we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to.
I will tell you, Mr. Murdoch passed a polygraph. Flying colors. Those 7 words were dropped into a Lexington County courtroom like a stone into still water. And for a moment, nobody moved. The statement came from defense attorney Dick Harpootlian, and it was not a metaphor. It was a claim about a machine, a needle, and a man accused of executing his wife and son. The same polygraph, the same examiner, given to cousin Eddie Smith, and Eddie Smith failed. Asked directly if he killed Paul and Maggie Murdoch. The needle betrayed him. That is the image you need to hold on to for the next several minutes. 2 men, 2 chairs, 1 question, 1 machine. 1 passed, 1 failed. And the state of South Carolina wants you to believe that neither result matters. Before we go deeper into what the documents actually show, make sure you're subscribed to the VerdictOrigin, because we don't just cover the story. We follow the evidence.
Maggie and Paul, you'll recall, were shot to death at the family's Moselle hunting estate on the evening of June 7th, 2021. Murdoch called 911 after returning from a trip to his mother's home, Almeda, and told the dispatcher that Paul and Maggie were hurt badly. It took more than a year, but Alec Murdoch would be indicted for Maggie and Paul's murders. Prosecutors with South Carolina's Attorney General's office said that Alec shot Paul with a shotgun and Maggie with a blackout rifle. Those weapons, they claimed, were family guns that never were found. Murdoch was convicted swiftly, but won a new trial due to misconduct by the disgraced clerk of courts, Becky Hill. The state's high court found that Becky Hill tampered with the jury and vacated Murdoch's convictions, sending it back for a new trial. Now Alec Murdoch, his legal team, and prosecutors are back in court fighting over a lot of things. Everything from where the retrial will be held to what evidence the jury will hear and see and whether the indictments will stand. On that last one, they will. Fat chance the judge is tossing them, but you never know. Today's hearing in Lexington County was supposed to be about procedure, but it quickly turned into a fight over secret deals, alleged police misconduct, and even a bombshell claim that the Murdoch murder weapons might be connected to another killing. Yes, you heard me right. I'll get to more on that in just a moment. But first, the hearing started with Alec Murdoch's defense team accusing the state of possibly hiding evidence that could help Alec Murdoch impeach state's witnesses.
As to secret agreements, there's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith.
Now, the hearing was supposed to be procedural, scheduling, venue, discovery, bureaucratic housekeeping before a retrial set for April 2027. But within minutes, the defense team detonated a sequence of accusations that transformed a routine motions hearing into an evidence war. First, they asked a simple question about Curtis Eddie Smith, a distant cousin of Alec Murdoch, a man facing his own charges for money laundering, methamphetamine trafficking, and a roadside shooting that involved Murdoch himself. Smith was identified as a witness, and his cases, 4+ years old, remain unresolved. The defense asked why. They asked whether a cooperation agreement existed. They asked whether Eddie Smith had cut a deal to testify.
Curtis Eddie Smith, who's a distant cousin of Mr. Murdoch, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdoch. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it.
Now that's Cousin Eddie, a distant relative of Alec Murdoch, who faces his own charges in a roadside shooting incident involving Murdoch. The defense wants to know this: did Eddie cut a deal to testify against Alec? But that wasn't all. Griffin then turned to SLED agent David Owen, the lead investigator in the Murdoch case, who also happens to be a former SLED Agent of the Year recipient.
With regard to credibility issues of police, we are aware that Judge
The prosecution said no.
Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file. Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter?
Then it was the state's turn, and lead prosecutor Creighton Waters fired back. He said there is no secret deal with Cousin Eddie.
First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, they, of course, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation.
There is no secret agreement. We have disclosed everything. But then came the polygraph, a proffer agreement conditioned on Smith passing a lie detector test. The question was direct. Did you kill Paul and Maggie Murdoch? Smith failed. The proffer was canceled, no deal, no agreement. And yet, the defense claims the state never disclosed that failure. That is the gap between what was officially said and what actually happened. The official position, no secret deal. The actual evidence, a canceled proffer agreement that looks suspiciously like a deal that died on the vine.
Bombshell.
Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdoch? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdoch passed a polygraph, flying colors. So the same polygrapher.
Now let me repeat that. The defense claims Cousin Eddie, a potential witness, failed a polygraph when asked if he killed Paul and Maggie. Alec Murdoch passed the same test. Creighton Waters fired back at that claim.
The case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that, it's not a lie detector. What it does.
And then the hearing detonated. The defense revealed something that made the prosecutor's eyebrows rise on the record. A recent murder in Allendale County. A ballistic analysis of shell casings from a .300 blackout rifle, the same caliber used to kill Maggie Murdoch. The extraction marks on those casings matched shell casings found around the Moselle estate and at a shooting range. The defense asked the impossible question: were the Murdoch murder weapons connected to another killing? If the same gun killed Maggie Murdoch and someone in Allendale County, then either the forensic test is unreliable, or someone out there is still using that weapon to murder people. The prosecutor, Creighton Waters, said he had never heard of it. He said he would be flabbergasted if SLED had that information and never told him.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right. I hope that answers your questions. He's going to get back with you. He's going to double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's going to get back with you. As far as the murder in Allendale, with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of, and we can go through a long litany of that. But there was a podcast. There's a reference to what I just said to you.
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
But we would ask that they look into that.
And I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened.
Flabbergasted. That is the word of the hearing.
We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdoch murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdoch murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdoch. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 Blackout at the house, at the driving range, and at the murder scene. Which leads us to, I mean, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdoch murders, either their test is bad or someone's out there using a gun to murder.
Now let the weight of that sit for a moment. A state law enforcement agency, SLED, which employed the lead investigator in the Murdoch case. An investigator who was named SLED Agent of the Year after this case, and who was later identified in a separate murder case where a judge dismissed the indictment for withholding exculpatory evidence. That same agency may possess ballistic data linking the Murdoch murder weapon to another homicide, and the prosecutor says he was never told. Here is the ticking clock moment. If the state's own forensic evidence connects the Murdoch murder weapon to a second killing, then every day of delay is a day that the unanswered question hangs over this entire case. How many crime scenes does one murder weapon leave behind before someone in law enforcement connects the casings? That is the moral refrain of this case: connect the casings. Because at the heart of the Murdoch retrial is not just a question of guilt or innocence. It is a question of institutional silence. The defense asked for SLED tips about other suspects. The state said it receives emails from all over the world. The defense asked whether the murder weapons had been found since the last trial. The state said it would look into it. The defense asked for the HR file of the lead investigator. The state said it would double check. Every answer was the same shape: a promise to look, a promise to check, a promise to get back. And yet the defense sat in that courtroom with a polygraph result in hand and a news report about an Allendale murder that the state had never seen.
We are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alec Murdoch participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligation seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but we don't have the benefit, we don't have the ability to contact law enforcement and get this information.
Assistant Attorney General Creighton Waters couldn't believe what he was hearing.
As to tips, we provided a lot of that information before, but as I said, this case was tried over 3.5 years ago, and so we are in the process of correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
Connect the casings, and then the venue ruling. The trial will move out of Colleton County. The judge found that fewer than 1 in 7 prospective jurors were qualified to serve in the first trial. The clerk of court, Becky Hill, was found by the state's Supreme Court to have improperly influenced the jury. The judge cited 4 grounds for transfer: the exceptional rate of juror disqualification, community prejudice, the clerk's misconduct, and the publicity surrounding the case. But here is what the judge did not say: where the trial will actually be held. That decision remains unmade.
Time around.
We would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the court's conduct about how certain people maybe got on the venire and others did not. She was apparently excusing people, we believe, and of course this litigation would help us. Litigation that's on appeal, of course, let us develop that. Her daughter appeared on the jury venire, and she, and I guess at the time, either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how she makes a great juror. She talked to me, I know she talked to you. I'm just saying, I'm not saying expecting that to happen again at a new court, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before she issues, he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. Would be my understanding of what normally happens
and when we
pick a jury here.
The prosecution won one ruling. Alec Murdoch's testimony from the first trial will be admissible in the second. The state argued it is the same case, the same indictment, the same allegations. The defense objected. The judge agreed with the state. That means the jury will hear Alec Murdoch's own words from a trial that was later vacated because the clerk of court tampered with the jury.
Suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? I'm not saying that could happen again, but I think I need to mention it. I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen the clerk of court interfere in this process. And clearly our Supreme Court found she did.
Judge McCaslin agreed to oversee the process. Now, the next big issue, where will this trial be held? The defense filed for a change of venue. They don't want this trial held in Colleton County or the jury picked from that county or the district where Colleton sits.
But everyone's going to know of this case, and everyone is going to perhaps have a preliminary opinion. The question is, can they put that aside and base their verdict on what you tell them and what they hear from the witness stand? So the second reason for Charleston is not only is it convenient, they've got a courthouse with 16 courtrooms in it. It's not going to shut down the county judicial system to try that case there. They did the Slager case there. Court operated normally, nationally covered case. Courtroom was packed every day, and it got a lot of attention. And right across the street, they tried Dillon Roof for 3 or 4 weeks. Didn't shut down the city.
But the state opposed the defense request to move the trial to Charleston, the defense's preference, to prove the point that Charleston wouldn't be too pricey. Dick Harpootlian actually called his co-counsel, Phil Barber, to testify.
Think about that. His testimony survives. The verdict did not. And so here is where the case stands. The retrial is set for April 2027. The location is unknown. The state says there are no secret deals. The defense says there is a failed polygraph that the state never disclosed. The state says it has never heard of the Allendale connection. The defense says the ballistic evidence exists and that someone should connect the casings. At the end of the hearing, the judge ruled the polygraph results inadmissible. The jury will never hear that Eddie Smith failed. The jury will never hear that Alec Murdoch passed. The judge was clear. Mention the polygraph and risk a mistrial. So the one piece of evidence that might have told the jury something true about 2 men and 1 question has been sealed off. That is what the court calls procedure.
I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial.
If you love digging into the details of these big crime cases as much as I do, you must download the Law and Crime Plus app. If you haven't checked it out yet, here are 3 reasons to jump on board today. Number 1, you get complete access. Watch the best shows from both Law and Crime and Court TV completely ad-free. Number 2, the case files. Get deep dive access to raw trial evidence, including body camera video, 911 calls, crime scene photos, and much more. And finally, it's free for 30 days. We are giving all of our viewers a full month to test it out completely risk-free. So head on over to lawandcrimeplus.com, enter the promo code CRIMEFIX, and start exploring today. Now, one of the most important parts of a trial, picking a jury, of course. And we all know what happened last time with the jury. There was some funny business. That's why there's a retrial. Clerk of Court Becky Hill messed with the jury. And Murdoch's defense team is a little paranoid that something could happen with jury selection this.
Now here is your call to research. The defense referenced a motion filed in the case of State v. Michael Kowachki, a murder case dismissed by Judge Roger Young in 2025 because the state withheld exculpatory evidence. That motion is public record. Go find it. Read the portion that names SLD agent David Owen. Ask yourself one question. If the same investigator was involved in both cases, and one case collapsed for withholding evidence, what should the defense be allowed to see in the Murdoch file? Leave your answer in the comments below. And if you believe the evidence should lead where the casings point, share this video with someone who still thinks this case was closed. Like, subscribe, and turn on notifications for the VerdictOrigin, because the retrial is coming, and we will be watching every document they try to hide.